Hey everybody, AJ Richmond here. Hope you're doing well. I am a criminal defense attorney in Forsyth County, Georgia, and I want to talk to you about the right of privacy versus the right of school safety. Now, a lot of cases have come up as to whether or not what can children bring on campus, such as elementary school, middle school, high school, even college. And particularly, there's a case in Minnesota about a school shooting. And really the question right now, it's the Crumbley case, whether or not a parent, mom or dad, or both can be charged with a crime for allowing their child to, number one, have a gun, and number two, be negligent with that gun. For example, bringing the gun in that case on campus. I'm going to be talking specifically as for Georgia, but currently in Georgia, the two cases that are used primarily are New Jersey versus T.L.O. That's a United States Supreme Court, but in particularly State versus Young, 234 Georgia Supreme Court 488, and that's the 1975 opinion that applies. And ultimately, the issue in Georgia is how to balance between protecting the students' rights, meaning what they can and can't do, or what they can and can't bring, or how can they be searched on campus, versus being safe in an environment, being safe on behalf of the other students to make sure that there's no guns, and whether or not being safe actually means you as a student or your children as students can bring a weapon on campus. So the number one thing that these cases implement, and whether or not your son or your daughter could be searched on school, that's the Fourth Amendment. The Fourth Amendment to the United States Constitution and to Georgia. And basically, are you free from searches and seizures done by the government without probable cause or without a warrant? That's really where all of these cases move forward on, and what the issue is. Now, let's talk about the New Jersey versus T.L.O. case. At this particular time, that is the case that really sets forward our standard currently. So that's about a high school student where he was suspected of smoking in the bathroom. The teacher and another student, teacher and another faculty member found T.L.O, who's the initials of the child, and another student smoking. They brought him into the principal's office. In this case, what's really important to know is that the principal searched the purse, and the principal found drug possession and drug paraphernalia. The child was then charged with juvenile delinquency, and in Georgia, you would go to juvenile court. The issue that made its way all the way to the Supreme Court was whether or not the search of the purse violated the child's Fourth Amendment rights. Was the principal able to search the purse without violating the child's Fourth Amendment rights under the United States Constitution? And as you could see in the slide, that case made its way from the New Jersey state courts to the New Jersey appellate courts, and then all the way up to the United States Supreme Court, which is very, very tough to do. But when you're dealing with constitutional issues, that's how cases generally go up the slide. The Supreme Court's case there in the Supreme Court was they were trying to balance what the privacy rights were and what the school's rights were. And you could see that the students' arguments said it's a violation of the Fourth Amendment. It was conducted without a warrant. It was conducted without probable cause, the two things you need. And the evidence, therefore, should be suppressed, meaning you did it wrong. You didn't have a basis to go in my book bag, and therefore anything found is what's called fruit of the poisonous tree. The school, on the other hand, through the United States government, said it was reasonable to search based on the suspicion that he violated school rules, such as he or she was smoking in the bathroom. And they had a duty to maintain a safe environment for the schools, for the other students. And most critical in this case, The search was done by a school official. It was not done by law enforcement. That's the key in the T.L.O. case. The Supreme Court, through a 6-3 decision, so it's binding precedent, said that the search resulting in the discovery, there was evidence of marijuana ultimately, that was reasonable. That while the Fourth Amendment prohibition on unreasonable search and seizures applies to school officials, they may conduct warrantless searches of students under their authority, that would normally apply to Fourth Amendment, meaning it was reasonable because they could do it as school officials, and there was no officers involved in the search. Okay, the officers weren't saying, "Hey, go search it." The officers weren't saying, "Give me your book bag." The principal was doing it all. So the balance is much harder to show that's a violation of the Fourth Amendment when there's no government, when there's no law enforcement action. So we have this sort of decision by the Supreme Court, and now it's applying to other state courts. So when the United States Supreme Court says to do something, all other 50 states are now required to do exactly what the Supreme Court said or follow those rules. We get to State versus Young. This is a Georgia Supreme Court case. That dealt with the admissibility of evidence obtained through an illegal search and seizure. And again, it involves a defendant or a child who was charged with possession of marijuana. This child was 17, and I think at the time 17 was a minor, but in any event, it could be a minor or an adult, but they were still on school. The assistant principal thought he was acting suspiciously. They were asked to empty their pockets, and the child tried to argue the same as the previous case, that his rights were violated and the evidence shouldn't be used against him. The court ruled that the evidence was admissible and that the child or the defendant was convicted. So why did the Georgia Supreme Court side with the school? You have the T.L.O. case out there, you have the Georgia Supreme Court, and the Supreme Court says it was conducted again by the assistant principal, not the police officer. The Georgia Supreme Court then breaks it down into 3 separate categories. And this is where the jurisprudence, this is where the law starts becoming, okay, this is guilt, this is violated in the Fourth Amendment, this is not. They said private people. So random people on the street, your friend, your neighbor, searching your house, searching your backpack. The Fourth Amendment doesn't apply. You can't raise a Fourth Amendment search, or you can't argue that it was criminal or it shouldn't be criminal because it doesn't apply. The next one becomes sort of the mix between T.L.O., the previous case, and this case. Government agents whose conduct in state action invoking the Fourth Amendment. Example, teachers. If a teacher searches a student's backpack, the remedy might be a tort. Meaning, if a teacher says, look, I'm going to search your backpack, they searches, they find stuff, you can sue that teacher for violating your rights. It may be still used against you in criminal, but you can sue them potentially for violating your Fourth Amendment rights. And the third category is actual government law enforcement agents, police officers, student resource officers that are police officers. When they violate the Fourth Amendment, it will be an unlawful search, and it can't be used against you. That's fruit of the poisonous tree. So going back to the T.L.O., the school safety wins, then why in this case is the Georgia Supreme Court siding with the school? And they cite, there's a very good cite in this case, and I've bolded that we conclude that in the good faith exercise of their public trust, teachers and administrators must be allowed to search without hindrance or delay, subject only to the most minimal restraints necessary to ensure students are not whimsically stripped of personal privacy and subjected to petty tyranny. It's a very minimal standard. If the teacher has somebody that they believe is committing a crime, we don't want them to just simply wait around if all it is a search. I think the difference is going to be if it's on a cell phone. If there's evidence on a cell phone, can a teacher still asked to search, 4, 5, 6 terabytes of information. Does that require school safety? Is the balancing shifted more towards school safety or not? So we have sort of the key takeaways. T.L.O established the standard of reasonable suspicion for school officials to search, and they have to balance that between the need for school safety and the privacy of students. We want to protect always against unreasonable searches and seizures, regardless of who you are. In State versus Young, the Georgia case, public, primary and secondary school students have minimal Fourth Amendment rights to be free from searches and seizures by school officials. So they're saying even at the lowest standard, at a public institution involving a school, there's got to be some type of Fourth Amendment protection for children, but it's outweighed if the teacher can show some type of threat to other students or school safety, the most minimum possible.